Thank you very much, Mr. President, and thank you for being here. It is a pleasure and an honor for me to see how an Italian association organizes a conference that is very vivid and dynamic. The topic that I thought that I could share with you this afternoon was to explore whether the directive on private damages has already to some kind of level playing field, a convergence between the law as applied by the courts and tribunals within the European Union on the basis of the directive. As you know, the directive had to be transposed by the 27th of December 2016, which is already 2 years ago. But the member states had also been given the possibility to determine on the basis of Article 22 of the directive how the transposing measures should be applied in time. Article 22 says you cannot apply the substantive provisions of the directive as transposed into national law retroactively. And with regard to the procedural measures of the directive, you had to ensure that claims that have been initiated prior to the 26th of December 2014 are not ruled by the rules of the directive. So we are now in 2019, and I do not have the impression, looking at judgments and decisions that have been made so far, that there is already a very tangible convergence and level playing field amongst the different courts and tribunals of the Union. And it has been demonstrated by a recent court case at the Court of Justice, a preliminary ruling rendered by the Court of Justice in a Portuguese case, the Cogeco case, where the court found, it was questioned whether the directive was applicable to a private damages case, whether the time limit that was applied by the Portuguese courts, whether that was compatible with the directive. The time limit was 3 years, and the idea was that the claim as it was brought was time barred. But it was then the question, is the directive not applicable, and should the rule, whether the transposing rule into Portuguese law, should that have not been applied? The Court of Justice found that the directive was not applicable, so the rules that were provided for in the directive as transposed into Portuguese law were not applicable. But, and that is the interesting part of the judgment, I believe, after that the court found that ratione temporis, that is almost Italian, is a little bit of Latin, was not applicable. It immediately started to explore whether the time limit as applicable under Portuguese law was compatible with the principle of effectiveness. And as you might also know, Article 4 of the directive explicitly refers to both the principle of effectiveness and the principle of equivalence. And it looks as if this judgment suggests that one can attempt, even if the transposing measure into national law would not yet be applicable to a case that is currently pending with a court or tribunal, that via the back door, or is it the front door, of the principle of equivalence, provisions of the directive might enter into a judicial debate that is currently pending, and that ratione temporis might be still outside of the scope of application of the directive. In the same judgment, the Court of Justice was also questioned whether a decision by the Portuguese Competition Authority was binding upon the judge for determining whether or not an infringement of competition law was available, and whether the judge should find that an infringement was available. Somewhat surprisingly, I have to say, and judgments of the Court of Justice quite often comprise a surprise, the court found that Article 102 was not applicable, and therefore it could not express itself as to whether or not the principle of effectiveness required the court to find that a decision by the Portuguese authority, whether that is, I'm going to use the word binding, upon the judge having to decide whether or not damages should be rewarded. And I thought that it might be an interesting topic to explore a little bit more in detail to see whether there is already any convergence as to what the status might be of a decision by a competition authority in private litigation that is currently pending or will be pending in the future. There are three types of situations which may arise. You have first a decision that is being adopted by the European Commission. And we are all familiar with the judgments of the court in Master Foods and others, and Article 16 of Regulation 1/2003. The directive does not change that. But I would already draw your attention that the obligation imposed upon a court when having to hear private damages in light of Master Food is to not take a decision that runs counter a decision of the European Commission. I'll come to that in a moment. If we then look at the obligations that are being imposed by the directive and need to be transposed into national law with regard to decisions adopted by a national competition authority of a member state, Article 9.1 provides that if a judge is confronted with a decision of an authority of its member state, of its state, that decision, if that is final, will be regarded as irrefutable. That is to say, the infringement of competition law, and only that, the infringement of competition law, is to be regarded as irrefutable. If it is a decision of an authority that is an authority of another member state, the value of the decision is somewhat lower, and it is a prima facie evidence. That is again Latin in Florence that is appropriate to use. Now, what is meant by that concept of not taking a decision that runs counter a decision of the European Commission in case of a Commission decision, or the, let's call it the binding nature of decisions adopted by the national competition authorities? Recital 34 of the directive gives some indication. It says a final decision of a national competition authority should be deemed to be irrefutably established, and then it gives a little bit more flavor, a little bit more meat to that concept, saying it relates to the nature of the infringement in material, personal, temporal, and territorial scope. Now, it has been, that obligation of Article 9 has been transposed in the law of a number of member states, and the UK still is on this day a member state. And you see that all of them more or less say that a decision of a member state authority is binding, and some member states go a little bit further with regard to the member state the decision of a member state authority of another member state as to what its binding nature would be. But it still leaves me with the question, what is exactly binding? How binding is a decision, and is a decision binding? And maybe that's some case law related to the United Kingdom's view as to what a binding nature of a Commission decision in a private enforcement environment could be, can enlighten us a little bit. There have been a number of cases that I list in this slide that have not really dealt with that question in the context of deciding whether or not damages have to be awarded, but in some preliminary discussions related to the disclosure of confidential information, including the level at which the Commission decision adopted should be disclosed to third parties. The decision where damages have been awarded and where the judge decided on the merits as to what the binding nature of a Commission decision should be is the recent BritNet case that was initiated against ABB. And the judge identified 3 elements, drawing predominantly from the case law of the European Court of Justice on the binding nature of an act of an institution, case law that has predominantly been defined and developed with regard to the question whether an admissible action for annulment can be initiated, which in my view is a somewhat separate question. And the judge identifies 3 elements. He says the operative part is binding, and then you might have recitals that are essential to find or to support the operative part of the decision which have a similar status, and recitals that have not that supportive effect, which are not binding with regard to the question whether or not I can decide a case that is compatible with the Commission decision. I have a little bit of doubt whether that is an appropriate way of reasoning. And let me explain why. A decision adopted in a cartel case is binding upon the company that has committed the infringement. It is not really binding, legally speaking, upon any other entity. It is only the company, the undertaking, and on top of it, the legal entities of the undertaking that are the addressees of the decision that are bound to pay the fine and to stop the cartel infringement. That is very clear if you question whether any third party can bring an action for annulment against such a decision. And the question then arises in a separate context where a third party, on the basis of such a decision, is claiming damages, whether a similar binding force, obligation, is imposed upon a judge. Master Foods only says that the judge cannot render a decision that is contrary to the decision adopted by the European Commission. So the judge cannot say there is no infringement. I'm fine with that. And the only binding part of a decision is the operative part, saying this is the infringement. Does that mean that any other element as described in the decision is uncontestable by the parties? As long as the judge confines with the idea that there is an infringement and does not deviate from that part of the Commission's decision. Imagine by pure hypothesis, a settlement decision. You have a number of companies that settle a case for one reason or the other, and that they acknowledge that they have committed an infringement from day A to day B with the territorial scope as defined in the operative part. What is the binding nature of such a decision with regard to the pure factual elements that might have led the European Commission to adopt such a decision? And is there no room for any debate anymore? Let me complicate the discussion a little bit more. Again, purely hypothetical. You have recently a number of cases where hybrid decisions have been adopted, where the same cartel, so to say, has been found to constitute an infringement by 2 separate decisions. If you follow the reasoning in BritNet and say that the recitals that are essential for supporting the operative part of a decision are binding upon the judge. In a cartel, most of the time you need two parties at least. Suppose that only one party is the addressee of a decision. Is then that recital also binding upon the other party that is not an addressee of the decision? Raising the question, I think, puts some doubts as to what the level of flexibility there is still with a national court to debate the very factual element as to what is the underpinning of the Commission's decision, without deviating from the Commission's decision that there is an infringement, but trying to clarify what the scope of the infringement is, not for the purpose of imposing a fine, but for the purpose of rewarding damages. I think that the Court of Justice will probably be confronted with a number of future questions on the interpretation of the directive as to what the binding nature of a decision of the European Commission or a decision of a competition authority of a member state will be. Thank you very much.